А, Очень рада приветствовать вас на нашем круглом столе. Сегодня такая интенсивная
So
рабочая
today we have intensive work ahead of us. We've already had a number of very interesting roundtable discussions. The topic of the Internet is the theme of several roundtable discussions. We will try to make our discussion most lively, most innovative, aimed at the new solutions. So we would like to have a true discussion, not just to mention that there is a problem like that and then there is a lack of regulatory measures in this or that sphere, but we will try to find answers and try to define the correct focus in the field, to understand better what the public sector should do in relation to the new relations that emerge in connection with the use of the Internet or other communication products and services. We will divide our session into three parts, and we'll try to structurize our discussion and speakers. We will divide the whole group into three subgroups, as I said, by the themes. So the first set of questions and issues we would like to discuss is as follows. You can see it on the screen, and it's a topic that is very close to me, because these are infrastructural projects, and the analysis of numerous investment projects shows that not a single one of the innovation-based projects can exist without a proper infrastructure, whether these are services in the Internet or mobile services, Skype and others, or in the field of the delivery in distance trading. And apart from the innovation-based ideas of what to sell and how to sell, it is also necessary to think of how to distribute these products, these commodities and services. Very often there is a conflict with the regulators, and the anti-monopoly regulation is set out separately here, but it's not just this area that is problematic for us, but the regulators indeed very often have a specific attitude to the projects that have a lot of participants who represent different sectors of economy, and there is a rather complex system of relationship between them from the legal point of view. So initially we would like to talk about the following. Any business works for a customer, for a final user. The user is the one who after all pays for all the infrastructural or innovation based projects. Let's remember that all the work done by business is for the customer. And within the framework of this discussion, first I would like to give the floor to the representative of the Ministry of Communications, Maria Kruchinina, for an overview. Good afternoon, dear colleagues. At this session, I will just talk about certain aspects of the regulation of relationship in the Internet sector associated with the use of the Internet. Can you hear me properly? Right. So all of us, business and the public sector, are interested in the development of the Internet industry, which is one of the major means of communication. Of course, the Internet, from year to year, has been taking more and more significant place in the life of every single one of us. And for the effective use of IT, with which the citizens of Russian Federation can really enjoy their right for information. A state program, Information Society, was developed. When drafting the program, the Minister of Communications and Mass Communications considered global experience and the current state of the market in general and the market of ICT. This government program covers all the areas of work, and it is aimed at a higher level of transparency and higher level of sustainability and competitiveness. And it's quite obvious that today the internet is not just a platform for the placement of information, but it's a very important part of business at the national and international levels. The development of the internet, particularly its Russian part, has a very serious impact on the development of the society, on entrepreneurial activity, and on the economy of the country as such. To be more specific, we can say that the internet is an innovative sector of economy and provides about 550 billion per year and grows 10% per year. For development, we need professional, well-qualified, first-class IT specialists. As it is known, any change of the business climate tells upon the rotation of the specialists, on the fact that specialists begin to move from one country to another, and ICT sector is very sensitive to that. According to our assessment and our estimates, had our specialists not left the country, then the volume of the internet market in Russia would have been 1.52 times bigger. Nonetheless, apart from 300,000 truly professional ICT developers of high level in the country, there are no less than 800,000 individuals for whom programming is a hobby. Definitely, we should not forget that information security is another key issue in the building of the information society. And it's very important to think about the security of the system functioning, protection of technologies, development of information in particular that is the information that is so important from the family point of view, individual point of view, to protect population and against terrorism, against extremism and others. The ministry has set the requirements for information security of the information systems and the information systems of the personal data, except for the personal systems for the critically important sites, information communication networks and other types of networks. With all of that, it is necessary to remember that there are certain acts, certain norms that limit the access to the internet. As it is well known, Federal Law 139 on amendments of the law on protection of children, and there are also individual legal acts that limit access to the unlawful information. As a result, the federal legislation has been amended. And we know that journalists called it the blacklist of sites. In order to enforce this law, the law which was enacted on the 1st of November, the ministry drafted some sub-laws, and in March 2013, the list of the banned information was supplemented. Unfortunately, the list no, we still do not know which federal authority is going to be executive authority that is going to be responsible for the control in this sphere. But this information covering personal information about children, victims of crime. And the ministry, together with Rospotrebnadzor, Roskomnadzor, and the internet community and the operators of communications, drafted some amendments to the resolution 1101 about the automated systems and the uniform register of sites. As for the regulation of relationship within Internet, the standpoint of the ministry has not changed. Although in the Russian Federation there is no specialized legislation that regulates the Internet, the general norms cover public relations no matter where they are, no matter what the environment is where these relationships emerge. We're talking about the Internet, the telecommunication network through which information is disseminated, and when information is disseminated through the Internet, Internet must comply with those requirements, those norms that are already stipulated by the Russian legislation in connection with the circulation of certain types of products. These norms regulate not just the Internet, but the public relations that emerge on the basis of its use. And in this context, allow me to repeat, it's not feasible indeed to have a separate legislation that would be dedicated to the Internet regulation. This regulation should be carried out through the amendments of the existing legislation. It is also necessary to remember that the Internet has its specific features, which are defined by its self-regulation and by the existing architecture. So participation in the drafting of the proposals aimed at the reforming of the system should be taken by the authorities, by business community, and by the NGOs. Moreover, some of the legal relations within the network cannot be in the hands of the state. There must be some mechanisms that effectively function, and in the process of which the civil society, business, and authorities communicate. With the improvement of the legal regulation of these relationships, it's necessary to keep the balance in this sphere, remembering that this sphere is most vulnerable because of the specifics of the activities within it. When preparing the proposals aimed at the regulation of relationship in this sphere, we must consider foreign experience and the practice of the international law. Norms of the law must be harmonized with the international legislation. We must consider the best international practices, the basic principles of which are self-regulation in business, information openness, and the principles of the limitation of the liability and responsibility of the information intermediaries. And the international experience is most important for us because of the trans-boundary relations that occur within the sphere of the Internet use. That's all I wish to say to you at the moment. Thank you very much. Thank you for this general outlook at the regulation within the Internet environment, and we would like to listen to the opinion of the participants of the round table about the Internet and whether the Internet is indeed a special sphere for legal regulation, or we can apply traditional norms here and methods. I think the answer, the question contains the answer. Had it been possible to apply the traditional system of relations to the Internet, we would not have been together here discussing all these matters. And I would like to quote in this context the draft concept of the public relations that emerge in the process of the Internet use, and what questions are to be developed further. The notions, the terminology, and well, it is really difficult to say anything against that. We come across this all the time. There emerge new words all the time, and very often it is impossible to translate these words into Russian. In the second and third part of our roundtable, we will discuss certain aspects like that. Crowdsourcing, for example, or crowdfunding. 3F, as Anna Fokina, who will speak in the first part, will mention these. These are non-existent notions in the Russian legal system and even in the Russian language. And then, of course, the terminology is to be further worked on, developed. Then the boundaries of responsibility and liability within the Internet, an enormous amount of work, because according to the Roman law, you transfer something to someone's, you can see, you know where the right of one person terminates and where the right of the other one emerges. But when we talk about innovations, when we talk about innovations in the limitless space of the Internet created by different entities and different individuals, then of course the boundaries of the rights, of the elimination of the rights and termination of the rights and the emergence of rights all these goes beyond the boundaries we specialists in civil law are familiar with. Allow me to give the floor now to Sergei Matveyev, who is Deputy Director of the Scientific and Technical and Innovation Policy Department of the Ministry of Science and Education.
Dear colleagues, frankly speaking, I don't know what I would talk about now, because the theme of the first block is the interaction of innovators and holders of the infrastructure. Probably it doesn't correlate with the themes to be discussed at this round table. Thirdly, we could speak about the issues related with intellectual property, because that is a common binding link between all the questions that were formulated, because the authors and the right holders developing any innovative business develop it on the basis of a certain infrastructure. The internet is one of the infrastructures that makes it possible with maximum quickness to bring all the result to the users. That is the difference, that the feature that distinguishes the internet. We might discuss these issues or those related with development of the public policy in the sphere of intellectual property, what the state is planning to do. We could speak about the development of the market of intellectual property and infrastructure questions that also arise. Sergei, how would I concentrate? Let us give you the floor several times during this roundtable discussion. Probably first we'll concentrate on the state policy, because Marina has already started that theme. Will you please carry it on? We have our task or mission or wish on behalf of the Council of the Federation and the government on development of the long-term state strategy in the sphere of intellectual property. Though that activity has been suspended, and we are working on the plan of the long-term events on development of the market and short-term plans for 2013-2014. What can be said? Any innovative business grows on the basis of intelligence and results of intellectual activity. So far, we can state, if we compare our market with international experience, so this market is non-existent here. There are many problems related to legal regulation, with the restrictions to legal regulations and with the economy that emerges, and how we formulate these ideas and how we commercialize them. The strategy proper involves certain important elements related with development of the market. The first key feature, which we always take into account, is that Russia has a lot of creative people. We have a well-rooted habit to invent, which has never disappeared. If that habit to invent is supplemented by high-tech services related with accounting, deposition of the ideas, creative works and scientific works, and state registration, if all these services are granted in a modern electronic form, our right holders will necessarily address this state information system to systems to receive the services and build new databases on the results of intellectual activities. That service-oriented approach should result in the growth of the volume of intellectual property. We are starting to change some legislative aspects. Everything that is created being funded by the state budget will be transferred to the executors, to those who created this intellectual property. It will not be returned to the state. At the same time, we'll submit the draft document to the government on transfer of the electoral resources available in the Russian Federation to the right holders, so that will be extensive privatization. And one of the questions for the discussion would be, what should be the state electronic services in the sphere of intellectual property? That is the common problem. The second major subunit is as follows. A huge growth potential is related to creative industries. Now we mostly speak about the internet as a medium where all the illegal actions are taken, all the possible actions. Our authors, so to say, unveil it not to receive their remuneration. And creative industries, which using modern communicational resources are well developed, are necessary not as a separate item in economy, but as an infrastructure for the use of innovations. No innovations will grow if they are not used, if the society doesn't consume them. And secondly, the creative environment is a large consumer of modern technologies and industries. The Creative industries speed up the industrial development. We need to adapt our creative industries for working in the internet. And there is a significant market where no information mediators are available. There is an author and a reader and some technical platforms in between. There is no editor, no seller, no bookstore that would be selling a book or a work of art. Everything is robotized, and the authors, Russian authors, trust high-tech services, but they don't always trust the editors. Figures are quite amazing, which I have been pronounced, and that information is given in the internet concerning the growth of Russian book industry in the electronic sphere. The growth of revenues in that sphere last year was 280% due to electronic sales of books. Russia ranks second in that sector after the USA. We're among the 4 top countries with more than 100,000 names of the books, and the market of offline contact of the books exceeded the best years threefold. Plus 300% of growth was recorded in France in 1 year, in 5 years. With us, that happened in 1 year. This is an example how high-tech services give a significant growth of the market. The questions that have to be regulated are related with the balance of relations in the digital medium between the authors, right holders, information mediators who emerge. Now, neither indistinct public policy and lack of regulation, transparent regulation, results in the fact that someone is getting revenues because the sphere is growing, and internet industry accounts for 1% of the GDP, even more, and that's good. But who receives these proceeds? If they were received by the authors creating content, probably the book sphere, the musical sphere would increase, but unfortunately it is stagnated. That means that monies and revenues are not kept at the point where they generate the ideas of product, modern innovative product, but it occurs in some other conditional spheres, and the sphere of information mediators, and in an indirect form. Thus, two key issues related to our strategy. We take into account the Russian habit to invent high-tech services, public services in the sphere, and the second part will be creative industries that will be removed from the gray area by regulating the relations, but providing the necessary preferences, because there are some problems with collecting taxes. And we have to collect, for instance, taxes, and that is a different story, not related with relations, or our collective management arises, and so on. And the third item to be developed are public instruments in the sphere of intellectual property. These are the instruments which should not be state. The state, in our view, should ensure the entire range of services on state registration and accounting of intellectual property, and the state should ensure an efficient system of protection that is the intellectual property proper related to intellectual rights. And in the working plan of the government for 2013-2014 that is currently being approved, by February 2014, it is planned to form the general model of protection of the intellectual rights concerning the first instant and the second instant, as everything in between the instruments, commercialization, monetization, instrument for the search of counterfeited products, infringements of the rights in the digital medium. That is not the task of the state sector. We think that private companies can develop these trends successfully using the state information systems and registers, which we should prepare under the first block of high-tech state services in the sphere, and many other supporting measures, which I'm not going to discuss here, including infrastructural measures. You are saying that the problem is related to interaction between innovators and holders of the infrastructure, but in the sphere of science, Ministry of Science and Education is solving that problem. We give a possibility of commercializing any ideas via innovative SMEs set up at the scientific institutions, high schools, And from September 2013, no restrictions will be imposed on the shares in the authorized capital of SMEs. So the high school giving out an idea if it is a right holder to that SME through its students, masters, postgraduate students and teachers, doesn't claim to have any share that might be 5, 8 or 10%, but at the same time these SMEs, irrespective of their share which they hold, the share of in the scientific or institution, can use all the scientific infrastructure. There are preferential rents for the first year that will be 40% for equipment of market price, next year 60%, and only in the year 3 or 4 it will be a market price. The scientific and education institutions can delegate their infrastructure to the SMEs without any competition, and a lot of other preferences are granted. So we realize that this task can be solved, and for our organization we have expanded it, but for the creative components I can tell you that such plans are being discussed at least under the strategy of intellectual property with the Ministry of Culture and the Ministry of Communications, Mass Communications. We discussed the question of the necessity of implementing a certain program of setting up the centers of collective use for creative industries, the places where the people can come, realize themselves, and subsequently enter a reasonable market. I have said a lot just to start our discussion as to specific questions and models concerning balances, relations, registers in the sphere of industrial property and creative industry. I think that we might concentrate on them in the course of the discussion. Thank you very much for your interesting presentation. You really touched upon a lot of trends which we are going to discuss today. Now, the Internet economy accounts for 4.6% of the GDP. Has it increased by 3% in 2 years? 3.5 trillion rubles if we count everything altogether. So we're speaking about a very serious economic phenomenon that is really quite hopeful, but the money should come to the place where the product is generated, as I have already said. We are going to discuss it later as well. And about levying taxes, it is also quite interesting because many European states are thinking about it, and I know that there is a French initiative to levy taxes from internet users if they are in France. But currently they have a special history with taxes, but such ideas were present at the level of the states in the European Union. I would like now to give the floor to Viktor Naumov, who will analyze the situation from the viewpoint of business, which he is consulting, being Napoleon Danton's company. Thank you, Anna. Good afternoon, dear colleagues. It's very interesting for me to take part in our discussion. I will try to start from the theory related with the nature of the relations that are formed in the internet, then passing on to some debatable issues, including the issues addressed to the participants who attend this conference. I'd like to note that if we analyze the Russian internet objectively, that is a dream of the innovator. Just remember what brands in the sphere of innovation technology appear when we're speaking about the Russian Federation. Kalashnikov, Sputnik should not be remembered. We remember social networks, search mechanisms, developers of antiviral programs, linguistic systems, reference information, and so on. Of course, there are relevant decisions related to hardware and in the sphere of industrial goods, but objectively all these companies and IT and internet succeeded themselves. They didn't have social markets of oil and gas or something else that is really worthy of respect. And in this environment connected with information regulations, there is a whole set of theoretical problems which have a direct impact on regulation of law enforcement with respect to internet development. information represents an electronic form. We realize that we should have the relevant legislation that is being developed based on the law on electronic signature of 2011 that was a bit delayed. We have some theoretical aspects related to concluding transactions in the electronic form, electronic consent for transferring personal data. These are the structures that are understandable now, that are covered by legislation or law enforcement. We should realize that in the sphere of the internet we have strong standards and protocols that are technical, the norms that are developed under the technical relations by the participants. And at these open standards and protocols, we base the entire exchange of the information, and they have a direct impact on the character of legal relations. And there is a very interesting feature which in fact is typical of other spheres, but to a different extent. With us, the level of self-regulation of relations in the internet is several orders higher than the average level in the material real world. The subjects themselves, from the users to system administrators, from communication operators to providers of hosting or specialized organizations, the sphere of e-trade, telemedicine, quite often themselves determine the rules which later form the business practice and sometimes are interpolated by the law. We should take into account that we have transboundary transfer of the information, which is quite painful globally, particularly in the last years, and it emphasizes the problem of jurisdiction of information relations, where the sovereignty of the Russian Federation ends and the sovereignty of another state starts. If we analyze the judicial practice in the third part of our section that we are going to discuss in the courts of the foreign states, we often consider the cases when the non-residents are the defendants, and sometimes both parties are not residents. These transboundary relations are the key elements of the international policy, and all the countries of the world try to agree and try to form their own viewpoints. And in the sphere of information technologies and the sphere of internet, there is a high level of automation. We have the algorithm that determine the volume of the information, the actions of the software, robots, search mechanism, actions related to processing of the information. A very interesting problem is related with the determination of the wills of the subject to relations. If a software was a device, if that is a virus, that is a modification, there is Article 73 of the Penal Code. And if something is more complicated, the robot takes the information from the sites, and the will of the person was not aimed at getting out some specific information, but some a significant problem which will be discussed a bit later consists in the fact that legal relations in the internet are multidimensional from the viewpoint of subject composition. We have got an infrastructure, electric communication, network communication operators. We have software and hardware and the developers that impact the relations. We have hosting areas where certain services are placed. These services and holders of the services are different subjects of relations. Objectively, we have the users who, for that sake, go to the internet for the sake of content and the services.
And sometimes it is very difficult to really speak about these contents and content services separately. It is difficult to distinguish them. Now, at the round table, we have already mentioned how the illegitimate actions of some of the entities lead to legitimate actions of others. So there is hosting, they sign an agreement, and the use of the hosting places illegitimate information. So when will the responsibility come for hosting? Of course, for the one who places this information, it should come. This problem of the definition of the level of liability in the internet is the problem that occurs everywhere in the field of intellectual property protection, in the sphere of confidentiality and state secrets. Then there is another problem which actively, contrary to the real world, it is very difficult to define the subjects, the entities, who is there sitting behind the computer. We have the IP address, we have logins and passwords which can be used by other legitimate persons or not. So there is a practical and theoretical difficulty associated with the identification of the entity. And this is a very specific feature of the Internet, and which makes the relationship in the Internet different from the rest of the world, real world. Moreover, the users go to the Internet for the content and for the services. And with all of that, if we talk about services, then we have information. The content is also information, but they're differently represented in movies, clips, books, and so on and so on. From the point of view of the theory information, there is a certain right. And of course, we can talk about the regulation of certain fields, and we have rights associated with that, and rules, and with the transfer of information, with the dissemination of information, with the access to information, the access to the information, not only about the individuals, but the public structures and many other types of information. And of course, many of these are results of intellectual activity, to 95% and even more. These are all results of intellectual activity. And here we come across co-regulation from the point of view of the intellectual property. If we look at the terminology, at the subjects or entities in the legislation, then certain categories in the different sectors compete with each other. Now, we can look at the relations from the point of view of the dissemination of information over the past 2 years. There have been serious changes. We mentioned already the law 149 and amendments to it, and Article 15, the list and the register of the banned information. We have now the term of dangerous and harmful information for children, banned information, and in this sphere we have a system of different types of secrets and confidentiality level. So all this has a serious impact and direct impact on the relationship within the Internet. So different sectors of different fields of law have their impact on the Internet. But if we look at the realities, at the judicial practice, we try to understand what's most painful for the sector. It seems to me that it's the definition of how the service at the site should be liable and responsible for the violation of the rights, the violation which is actually exercised by the clients of this hosting. If you take as plaintiff one company or individuals, and of course there are also people who are accused of the violation, and so it's not the problem of placing a certain service. It's actually the acting, the work of those who make use of this particular service, violating intellectual rights, using the brand name, or using some information associated with the business reputation of a company or an individual. Well, of course, it is very simple from the point of view of the theory processes to prosecute these individuals, but where we need to find out who the subjects, who the entities are. Sometimes it's very difficult, sometimes impossible. So individuals who believe that their rights are infringed directly file claims not against those individuals who do actually something, but against those who create conditions of information dissemination and, for example, and react in different forms. For example, if there is a claim, and if there is a claim of an individual who believes that his business reputation suffered, so when the service reacts or does not react, this needs to be considered. So the limits of liability of the information providers or intermediaries is a serious problem, not only for Russia but for the world. It's the cornerstone of the management and control in the information space. It's most obvious and most painful in relation to intellectual property, because there are classical interests of the classical intellectual property. It's subjective, and of course there's a monopoly, so it's the topic of the parallel roundtable dedicated to intellectual property. But let's remember, this is all permitted. Then, on the other hand, there are needs and interests of the users who want to copy anything they want, but they do not want to pay, or if they wish to pay, then they want to pay minimal. They want circulation of information, and there are also business interests. The operators are interested in the largest possible turnover information. So there are compromises, but there are also differences of interest. If you look at the practice of Russian courts, so it's very difficult to say still yet when whether there is a true liability comes for the content. Of course, there were clarifications given by the Supreme Court. The Agava case, for example, a couple of years ago. This is the Supreme Arbitration Court ruling, who listed several criteria. So when these criteria are followed, when the site, when the service, when the intermediary act reasonably, then he cannot be held responsible. There are other solutions and other decisions and rulings, but they're different, and you will see that in different regions the approaches are different. Methodology, even methodology, is very different. So actually looking in different directions in many ways. We don't have a detailed legislation pertaining to that, although it was in the year 2006 when the legislators began to work on that, began to work on the issues of legal and civil liability. But the law on information does not cover the protection of intellectual property, then these structures are not applicable here. And in draft law part 4 adopted in the first reading, there is Article 53 prim, and there is a part dedicated to ideology, because its ideology has actually been implemented. When there is a warning, the service doesn't do anything, it can be held liable. If the service does something, it depends, of course, on how much and how soon, then it can get a certain immunity. These models are quite difficult, and today, on behalf of the legislators, there emerge new approaches. The registers of the intellectual rights, for example, which contain digital copies of something, and with the help of automation, it is possible for the sites, for the platforms to get assistance of this mega sensor. And objectively, these models are being discussed theoretically, I said, but technologically they're non-implementable yet, because these are not trademarks where something can be just compared. These are high volume pieces, and it's just impossible to carry out this work with them. So this whole set of contradictions of interests in this field dictates several ideological issues to us. So there was information, e-information is developing, we have an e-space in the state, we have strong telecommunications, which is all done by the operators and by the state. And of course the users, at least the users think so, would like to feel comfortable. The right holders do not always agree with that. If you want that, then sign an agreement with us, otherwise pay money. And there is a whole knot of contradictions. If we look at the trends in judicial practice, they become more obvious. If we look at the draft laws of the last half year, from the on the site of the High School of Economics, for example, it is still not clear how it works. The site, the right holder and the user, how should they act and react? The Canadian way is somewhat more complex. It's very similar to DMCA. And with the European Union, we can say that there is a lot of liability. A lot is on the users and on the operators. We can choose that, but we probably prefer a freer system, because there is a certain level of the intellectual property violation. But since the industry of innovation and telecommunications develops, then we can just suffer it. The monopoly on intellectual property is good and beneficial for those who own it. So we can compare everything to understand what is more profitable in Russia, where in this industry there are the right holders. So these are the questions raised by me for you, and this is the end of my presentation. Thank you very much. That was another very interesting presentation. Allow me to give the floor to Eric Goldman, professor of the Santa Clara University, for us to look at the more promoted and better developed foreign institutes that make regulation possible.
Greetings from the Silicon Valley. I'm delighted to be back in St. Petersburg, my second time here. And St. Petersburg sparkles in the sunshine. I, however, was not prepared. I did not bring my sunscreen. Nevertheless, I'm delighted to be here. I have some prepared remarks, but before I get into those, I do want to mention a couple of things about the discussions of whether the internet is something different than we've seen before and if existing law can stretch or apply to the internet. We've learned a lot about the internet over the last 15 to 20 years. And there's two things that stand out in my mind about how the internet might be different than things we've seen before. The first is that the internet enables a common market, buyers to coalesce in one single marketplace and it creates larger markets for sellers and allows sellers to distribute to wider audiences and achieve larger economies of scale. So part of what I think we're fighting for with the internet is to protect this potential to build a larger common market that makes marketplaces more efficient. And I fear we are actually taking steps backwards. We're fragmenting the common markets and making it harder for people to make matches between buyers and sellers. The other thing that the internet's shown us is that when the costs of communication are low, people want to talk to each other. The internet has proven to be a medium that enables conversations that never would have taken place before. And every new way of communicating amongst people creates a whole hotbed of activity, a whole groundswell of activity that we've never seen before. People like to talk to each other offline too, but the conversations that take place on the internet are different than anything we've seen before. And there's more of them. And there's different communities that have formed that we've never seen before. And the internet's low cost of communication and the ease in which the user interfaces enable communication has created conversations that we would never see in any other circumstance. And I think both of those points, the common markets and the low cost of communication to create conversations that didn't exist before, are worth fighting for. I want to turn to a different point, how we think about regulating the internet. And I'm going to bring a US-centric perspective here. I think that's why I was brought here. But apologies if I'm not being responsive to discussions about things that are taking place in Russia that I don't fully understand and that lots of people have a lot of energy invested in, and I'm not talking about those. This is based on a paper that I did make available to the conference organizers, and if you want, I'm happy to provide to any of you. I didn't bring hard copies, but I can get you an electronic copy. I'm going to start with the presumption that the rule of law is in place in a country thinking about regulating the internet. In other words, that we already have predictable laws, that we have non-arbitrary enforcement, that we have due process. If we don't have those, then we need those in order to have a stable internet. But I think that we're going to assume that we have that in Russia, and that in many other countries, we're going to assume that we have the rule of law. Once we have the rule of law, then we want to think about how we wield the laws to accomplish our goals. And I'm going to argue in favor of the merits of safe harbors and immunities. And I'm going to tell you how we can design them to accomplish our goals. Let me define my terms. A safe harbor is a defense against liability for taking specified actions. If you do the following steps, then you have a defense. An immunity is a defense against being sued in the first place. No lawsuit is tenable if the conditions are met. And I'm a big fan of safe harbors and immunities because in my mind, they're part of the infrastructure that allows entrepreneurial activity to take place. In a sense, by reducing the legal risk that entrepreneurs face, it enables entrepreneurs to make investments that are more predictable and have less risk. So it's a way of stimulating in entrepreneurial activity. It's a form of subsidy to entrepreneurship. What we've seen in the United States is that entrepreneurial ventures are killed off by lawsuits. Someone comes up with a good idea, they try and bring it to marketplace, someone doesn't like it, they sue them out of existence. And we've seen this over and over again in the United States. Now, some of those lawsuits are justifiable in the sense that the entrepreneurial activity was illegal and we don't want that kind of activity. Others are not. Others are simply a form of legal risk that moots all the other entrepreneurial investments that are being made. So the idea behind safe harbors and immunities is to channel the entrepreneurial activity into productive ways, to tell entrepreneurs, if you go this route, you don't face legal risk that will moot the rest of your investments. There's another bonus to safe harbors and immunities. If they're designed properly, then they can act as a way of avoiding the problems of overlapping regulations. One of the biggest problems entrepreneurs face is that there's not just one law they have to consider, there's dozens of laws, hundreds of laws, dare I go to thousands of laws, that all overlap on the same entrepreneurial activity. And if we come up with a good safe harbor and immunity, then the entrepreneurs only have to comply with that particular law and don't have to worry about those other laws that might exist. In some sense, one of our biggest problems for entrepreneurs is that regulators are going to regulate. That's what they do. That's their raison d'etre. Sorry if I'm messing up the translation there. We can let regulators regulate. Let them do their thing. If we create a strong enough safe harbor and immunity, all that activity should be outside the scope of the regulator's reach. If I've sold you on the idea that safe harbors and immunities are a good solution, let me tell you how they can work best. There are 7 design principles. 1, minimum formalities or prerequisites. Don't make the entrepreneurs jump through specific requirements in order to be eligible for the safe harbor or immunity. Don't require a registration scheme. Don't require a set of preconditions that must be complied with. The second thing is that the safe harbor or immunity should have a small number of elements that the entrepreneur must satisfy to be eligible. In other words, the more elements that the entrepreneur has to satisfy, the more places that a lawsuit can pick apart. And we've seen that in the United States where we have the online safe harbors for copyright infringement. A defendant has to satisfy 14 different requirements. Guess what? 14 different bases for copyright owners to complain that the safe harbor should be lost. The safe harbor or immunity should have what I call global preemption, not global in the geographic sense, but it should preempt all the laws that might apply in the activity. It should cut across all of them. If it doesn't, then if it takes care of 9 out of the 10 applicable laws but leaves one open, then all the legal regulation will go into that one, and guess what? The immunity or safe harbor is worthless. There should be no ambiguous terminology. I don't know if this will translate. There should be no weasel words. So for example, the words good faith as a requirement of a safe harbor or immunity is worthless because a judge will tell you when they think there's good faith, and that's not a predictable foundation for entrepreneurs. If the safe harbor or immunity depends on the defendant's knowledge, then the knowledge should be very specifically described about when the entrepreneur has it. The 6th requirement is that the safe harbor or immunity should be quick to resolve. It should end lawsuits early, not later. Later lawsuits are more expensive. And finally, there should be sanctions for bogus claims. If a claim is not meritorious, then the person who brings a claim should have to bear some consequence. I'm going to give you an example of how we've done this in the United States. I'm going to describe 47 USC 230. This is the law that says that websites aren't liable for third-party content. This is a rather radical concept. It's globally unique. Most countries have adopted rules that at best, say that websites aren't liable if they have received a notice and respond to it expeditiously. That is our rule for copyright infringement. But in all other respects, the United States has said websites are not liable for third-party content. If the claim is based on third-party content, the website cannot be held liable. It is an immunity, and a very powerful one. There are a couple of exceptions: intellectual property, federal criminal prosecutions, and then a third one related to privacy. And Section 230 has been the basis of the United States' global leadership in user-generated content. If you wonder why so many of the entrepreneurs are able to succeed in the United States building sites that let people talk to each other, this law is part of that infrastructure, part of the inputs that the entrepreneurs rely upon. Why does it work so well? Let me run through the 7 things I described to you. There are no formalities to qualify for Section 230. No papers have to be filed with the government, no boxes that have to be checked off. It automatically applies to websites just by virtue of being a website. The second is that there are only 3 elements of a successful 230 defense. There are only 3 things for plaintiffs to fight over. Because there are so few, the plaintiffs can't make much progress. Section 230 preempts all claims. It doesn't matter if a plaintiff is upset about defamation and also pleads that there's emotional distress or that there was unfair competition, or pick your other type of defamation-like claim. The law applies to all of them universally. There are no weasel words in Section 230. Now, there's a separate provision in Section 230, Section 230C2, that requires good faith. And the defendants never use it because the good faith requirement makes it so that it's not effective. Another provision lacks the good faith requirement and is quite effective. The knowledge of the website is irrelevant. It doesn't matter if they know there's a problem, they're not responsible for it. Section 230 resolves quickly. It's usually awarded on a motion to dismiss. In other words, plaintiff files the claims. Defendant says no claim is appropriate here per Section 230, case ends. No discovery, no jury trial, no additional proceedings. And finally, though there aren't sanctions for bogus claims in Section 230, it's often companioned with another law that makes the plaintiffs pay the defendant's attorney's fees. I don't know what Russia's laws are. In the United States, attorney's fees are not awardable as a matter of course to defendants, but in some cases, in fact, when people bring bad Section 230 claims, they still pay their opponent's attorney's fees. And so Section 230 provides a template or a model of how a immunity can create the infrastructure for entrepreneurial activity that will lead to the investments that I think the Russian economy might be interested in, and certainly has been a boon to the US economy and to the Silicon Valley economy. I'm going to conclude just by mentioning 3 risks when we talk about safe harbors and immunities. I would be derelict if I didn't mention them. It's hard for regulators providing the safe harbor or immunity to anticipate what the marketplace needs in advance. The good news is, if the safe harbor immunity is on the books, entrepreneurs will figure out a way to take advantage of it. So it's like a tool that you provide to the entrepreneurs. They'll find a way to do what they can, but it is hard to guess what they need exactly. The second problem that we face is what I call rent seeking, which is people saying, I want safe harbors or immunities because it's going to be in their profit maximizing interest to have it. And so this is a common problem with regulation. It's also an issue when you deregulate. And finally, a good safe harbor or immunity means that victims lack recourse. Now, I put the word victims in quotes. We make a social choice when we say someone has a legal claim or not. But the whole point of a safe harbor immunity is to say certain claims are not meritorious. And in some cases, that means those people lack legal recourse. We have to be prepared to make that kind of hard decision if we want to get the entrepreneurial activity that we seek. I appreciate the opportunity to make some remarks.
Спасибо большое. Не могу не отметить тренд.
Thank you very much. I can note the trend of our discussion. We started with building registers of prohibited sites and greater responsibility. Now we have come up to the questions to determine the limits of responsibility. May I ask a question? A major emphasis was placed on the matters of such quarantine zones or immunity zones where no rules, actions where business can be developed. Don't you think that the Russian internet business is rather well developed for creating such quarantine or immunity zones? Probably we should immediately pass on to developing the explicit rules of the game. Allow me to finish, and then I readdress the question. So, from the definition of the subject of the responsibility, we passed on to the following. We have to create a comfortable environment for SMEs by two instruments which were offered by Eric. First is entitled Safe Harbor, and then immunity. These are not free zones. They are not related with free territories. These are certain legal rules that make it possible to, by a simple check, to ensure intactness in respect of not violating the rights of the third parties. So your question probably should be worded in a different way. Probably, do we need any specific rules, or probably it would be better to build everything immediately, because we're quite honest in respect of legislation and we can build anything. We don't have any long-term history and the market is already developed, and we can structure it immediately without any special reservations.
I'm sorry, I didn't understand the question through the translation.
That's really difficult to understand.
Do
we need to create these harbors or immunities, or we have enough developed internet to just create rules? That is the essence of the question.
Okay, thank you. So the question, I think, assumes that there's a point at which we go from needing to provide installation to the internet to where we can say no more installations required, let's go ahead and control the activity on the internet. And my argument is that whatever snapshot of the internet we have today, it doesn't tell us where the internet will end up in the future. So we can't rely on the fact that we've done so great so far. I'm interested in the next round of innovation and the next round after that. And the safe harbors and immunities are the kinds of preconditions that allow us to achieve the next round of innovation.
I would like to add that no one is saying that safe harbor is a special or temporary measure. That is an approach that is being declared and that makes it possible for the Silicon Valley to develop business as they are developing it. That is not a temporary measure. That is a constant rule of behavior that is applied for the participants of this market. Now microphone. Really, that is a soft mechanism for regulating that makes it possible observing a simple set of rules, not to be the subject of responsibility. That also partly solves the problem of revealing the subject who has violated the law, as was mentioned by Victor. Thank you very much. Now I'd like to give the floor to Denis Pak, who is Director of the Department of State Regulation of Internal Trade from the Ministry of Industry and Trade. Thank you, Anna. It is pleasant to come back to my native city to attend the International Legal Forum, despite the fact that initially I planned to make my presentation the theme Internet e-commerce, but taking into account this discussion, I would like to dwell on two other units, and I'll try to be brief. The second part, take into account the statements that are made on the actions of right holders. This is the discussion that is carried out by the government concerning legalization of the parallel import, and there are different opinions concerning the consequences. And the third aspect is how our Ministry of Industry and Trade is working or is planning to work with results of intellectual activity which it has accumulated for a great number of scientific research and design and experimental works. Probably these things are not interrelated, as it would seem. For instance, parallel import has a direct impact on the trade, e-commerce and innovations. Coming back to e-commerce, I would like to note that despite the fact that in Russia there is no official statistic observations of the internet trade, all the figures which we operate are just evaluations. It is clear that the sector is growing much quicker than traditional retail trade. We can also indirectly see it from the problems arising in the mailing system of our country. According to the Morgan Stanley research, the extent of internet trade in 2012 was $12 billion in Russia. That is less than 2% of the turnover of all the retail transactions. According to their forecast, that share will increase to 4.5% by 2015 and by about 7% by 2020. That will account for $72 billion. Thus, the market has a high potential and is quite interesting for all the participants. The number of companies in this sphere is assessed at more than 20,000 in the opinion of the experts. And these experts note that only a small share of these companies would observe the current Russian laws. In many respects, the market of the internet trade appears, due to its specificity, beyond the framework of public control and supervision. As a result, there are specific forms of deceiving the customers, such as non-information about the possible places of return, improper information concerning the delivery and consumer properties of the goods. Despite the fact the internet mostly doesn't impact the condition of traditional retail trade, all the major Russian retailers started to develop retail trade sales actively. Our market of internet trade is not comparable with that of the USA or the European Union. Based on the assessment, the US market is $200 billion, but taking into account the development prospects, it is quite interesting. Now, as to the problems related to legal regulations and the challenges which we face as potential regulators of this space. In fact, the challenges in the internet trade are not related with trade, but the first component is the internet space, and they have already been mentioned here in a greater or lesser detail. First is the determination of the applicable law and jurisdiction when concluding the contract on such remote trade. As all of us know, the website can be registered in one domain zone, the server might be in another state, and the seller and the organization might be set up based on the laws of the third entity, and the warehouse might be in the fourth country and the buyer in the fifth country. The problem of defining the applicable law is existent, and in our legislation so far we haven't solved it. The second point that has already been mentioned, that is the determination, identification of legal relations between the parties. The consumer purchasing the goods through the internet shop should always have the right to further judicial protection. Thus, he should identify the person or organization or entrepreneur with whom he establishes these legal relations and concludes a contract. Currently, this question has not yet been solved by our legislation. There is an opinion that the introduction of a certain, possibly a voluntary register, will widen, so to say, a part of the market, and thus these legal relations will be in a more civilized format. The third challenge is that, as has been already mentioned, electronic document circulation and document circulation in general. How is it necessary to corroborate the fact of concluding a contract? In the European Union, the directive of 2011 generally regulates that matter. In our legislation, there is a certain gap, and probably there are some grounds for the state to propose a certain decision similar to that taken in the European Union. And the next problem is the activity of the information mediators. I won't dwell on it in detail because it is quite obvious that the activity of such sites as Yandex Market, Goods Mail.ru are currently outside the scope of legal regulation, and probably we can adapt certain principles that were developed for the file exchange services and social networks to determine the limits of their responsibility. The next challenge is protection of the information from unauthorized access. This is due to the legislation on personal data, when on the one hand the citizens do not entrust their personal data. They are not sure that in case of transferring the personal data to the internet shop, they will be kept secret. My apologies for interrupting you. As to personal data, we would like to discuss them afterwards, after the break, and because we have a lot of themes and we have to structure our discussion. I will tell you briefly that this problem is associated with electronic payments, and moreover, there are services, a PayPal service, which makes it possible not only to transfer the money, but also guarantees the receipt of goods. If the goods are not received, the consumer, the person who is buying the goods, might get his money back. So currently, in the Russian segment of the internet, we don't have a similar payment service. Probably that is just brief information concerning internet trade or e-commerce. Now some words about the discussion of the government concerning legalization of the parallel import. Parallel import is interpreted as unauthorized bringing of original goods that are protected by the trademark into the Russian Federation. In Russia currently we have national or regional, speaking about a common economic space, the regional principle of exhaustion of the rights. The Federal Anti-Monopoly Service acts as the main adherent of passing on to the international principles of the exhaustion of the rights. That means that if the goods is in illegal circulation in any country of the world, it might be brought to the territory of Russia without consent of the right holder, not only for consumption but for business services. The Federal Anti-Monopoly Services thinks that passing on to the principle of the exhaustion of rights will increase the international competition, and the Russian Federation is currently an importer of the international intellectual property, thus that will speed up the innovative refurbishment of the industry.
At the same time, our ministry and the Ministry of Economics and all the big businesses stand against the introduction of this principle. Why? Because parallel import puts the right holders and their licensors and licensees actually in different positions, and as compared to those who do not who do not have the right. And if the first invest money into localization of production, to market development, the parallel importers are acting as parasites on this infrastructure, applying different grey schemes of turnover. And in case, if we take domestic equipment, almost 45% of the equipment that is being sold in Russia is manufactured in Russia, and this is mostly localized manufacturing. This actually means that considering the fact that production cost in Russia is higher than in some countries, this will lead to the situation when all the manufacturing is localized in Russia. All localized manufacturing will have to be closed, and actually we will have to start manufacturing in the third countries. And this will not only lead to curtailing of budget revenues, but the investment attractiveness of the country will suffer. In case of the legalization of a parallel import, there must be some short-term impact associated with the reduction of consumer prices, but it's difficult to assess that. We estimate it to be, on the average, 3 to 5% for customers. So this is the discussion we have at the moment, and it's interesting to know your opinion. We would like to know more about foreign experience. I know that even in those countries that are formally in the countries where the international principles of exhaustion are introduced, there are still very strict technical barriers and other barriers that do not make it possible to import the commodities that are not used, that are not meant to be used on the territory of the country. Then briefly about the work of our ministry and plans of our ministry in relation to intellectual property accumulated. As it has already been said by the colleague from the Ministry of Education, first of all, I need to say that the ministry spends on design work and R&D over 120, 130 billion a year. Now, this money is allocated for the support of innovation in the industrial production. Of course, some money is spent on defense, so it's a secret non-transparent sphere, but some money goes to the civil manufacturing sphere. Everything that we are planning to spend on civil production in the future, patents and know-how that are being issued. We would very much like to make sure that under these conditions, actually the owners stay the owners, and we are willing to transfer free intellectual property created with the assistance of the state. Well, we are discussing at present whether these right holders will have a liability to commercialize their patent. The Minister of Education is against these proposals, but we believe that the commercialization duty with people who have received some money from the state and invented something should exist, and this is our principle. That's in relation to the future property, but as for the accumulated property, industrial property, we believe in the following. The ministry, the Russian Federation Ministry has about 700 patents and about 7,000 objects of know-how. This is not registered, of course, and mostly kept on the shelves. And unfortunately, at present, we do not have sufficiently clear for the state and for business mechanisms of transfer of this intellectual property into the commercial circulation. And as far as we know, there is a draft document prepared by the government that will enable us to get this intellectual property and then transfer it to business free. Because we are not planning to make money on that. We believe that our main task is to improve the competitiveness of Russian industry and Russian economy. At the same time, of course, we still have a lot of unresolved issues associated with taxation, royalty, authors' remuneration. So they're still unresolved. That's what I plan to speak about. Thank you. Thank you. That's indeed interesting to see. The public sector always wants to invent some sort of responsibility and then to start regulating it. So something that is attached to any right. Not really. No. We've had this discussion with the ministry. But really, this discussion should be not here, not at this platform. The last the last session was within the government. We can set responsibility associated with commercialization, but how to punish those who do not commercialize? Criminal code should be applied, or administrative code. So I have a patent, but I have not been able to commercialize. So there can be different reasons. Microsoft, for example, announced a much more interesting solution that I can offer, designing and developing my own e-book. So different circumstances can emerge. But as for the intellectual property, it is already in the hands of the public sector. The civil code, fourth part of it, does allow it. Results created with budget money could provide the rights to the executor. But we were able to see that really it's very difficult. There are two complex situations. Nobody knows what is happening. And if it's the executor who has the right, then the public entity is under complete control, and they have to account for all the money spent. And so the commissioning body, the public authority, should not get involved in commercialization and to the economics. And we came up with the initiative. That was the decision of the President of the Russian Federation to reduce the list of cases when it stays with the executor. So there are just two cases in this list. First is the situation when the result is made for the execution of the authority of the bodies of power structure, and second, if after 12 months upon the obtaining of the result, then the executor is not doing anything, then Russia will hold it. Is it for civil, military, or for military? Now that is strange. It's going to be very difficult. Civil. Let's not continue this discussion here. That's an interesting issue. There are other constraints associated with state secret and the extraction from the circulation in turnover. That's where privatizing, indeed we're talking about the privatization for the interests of the state. Whether we agree with the ministry as here. We believe that all the authorities that have intellectual property and are holders have to carry out the inventory of it, and if the intellectual property is not used, it must be displayed on the internet on their sites. So again, without the internet we cannot do anything, and within 12 months the executors, the developers, can revoke the right and can take it back. So the ministry is working now with the patents and with all the know-how. So if the executor does not take away this right, then the license can be transferred to any economic entity for commercialization on the territory of the Russian Federation. We believe that this might work. We don't want the state to be a sort of a idly barking dog. And it's the special resolution in covering the intellectual property at the disposal of the Russian Federation. So the president actually ruled to adopt all the amendments to the legislation by July. So this is an interesting trend. As a moderator, I must remind you of time and allow me to give the floor to Mikhail Yatsenko, who is the Executive Director of the National Association of Distance Training. And then we break for coffee, and then we look at the protection of personal data, information, and mechanisms of innovation support using the non-public methods. It's difficult to do it within 1 minute. So within 1 minute, I can just say thank you for the invitation, and that's it, and enjoy your coffee break. While sitting here, I discovered quite a lot of stones thrown into my orchard about the forecasts and market growth, about the violation of legislation by the distance traders. No, we do not have exact figures, unfortunately, here, and we don't know how to get hold of these numbers. Nobody knows that yet, and there are just estimates. And as far as I know, even prior to the time when Minpромtorg had received the right to control trade, the Ministry for Economic Development tried to do it, and the statistics specialists tried to introduce different statistical forms that the companies were supposed to fill in with the purpose of accumulating official statistics about the sales volumes. But internet trading and distance trading is not always that clear. It's not always easy to understand where money comes from. It's just one example. Mvideo. They have an internet site, and they have an offline shop. And nobody can say, thanks to what they have money, and what is the source of the money. Even if there is a strict system of accounting within the system, if they close the shop, the internet sales go down. If they stop internet selling, then the shop is going to suffer. So it's a difficult correlation. But as for the non-enforcement of law, the rather violation of law, there is a different look at. There are some companies that do not comply with law at all, but there are sometimes objective and subjective reasons for that. In my opinion, it's rather difficult to follow what is being commented from year to year by those who actually develop or draft the laws and rules. And from year to year, there appear new options, new versions of one and the same text. And I direct this criticism at the Ministry of Economic Development. They manage to comment one and the same text often enough using different approaches, and so it's very difficult to comply with this particular type of legislation. Moreover, since we talk about legislation, consumer legislation is written in such a way that it does not consider the specifics of distance trading. So I believe that it is necessary to exercise a very different approach to the drafting of the law. I'm absolutely against special legislation for the internet, but on the other hand, and here I support the initiative of the Ministry of Communications, when drafting legislation, still we must consider the specific features of the sector. I can give an example. There is an internet shop that sells blouses. And this blouse is manufactured, let's say, in 2 or 3 countries as a test. And if it goes through testing, it can be manufactured in 12 or 13 countries. It's a brand. I'm not going to give the name of this brand, any brand that you really prefer, you like. And you can be sure that actually the manufacturing is not always in one country, and the French blouse is not always French from the point of view of the country where it was actually sown. And so the consumer legislation requires that the customer gets information about the country of manufacturing, the country of origin. Why do we need that at all? How is that possible in the present-day world? Maybe this should be revoked. No, it's not the question. The question is not to me. You can initiate it. Today I was at the roundtable discussion for lobbying, and I was saying that lobbying is most important. It is a democratic form, and so develop a law, draft a law for distance trading and discuss it in detail. We work on that. We cooperate with the Ministry for Trade and with the Ministry of Public Health and Social Development, and we talk about this. Probably what we talk about is not that well supported by proper arguments, but the International Convention on Distance Trading, which came to us in the year 2004, is actually an informal agreement between 24 countries. They are members of the European Association of Distance Trade. And we can find certain elements of it in Article 24.1 on distance trading. Some commas were left out, some phrases were forgotten somehow, and here is what we have. Anyway, it's after all good that we have something, because prior to that there had been nothing. So it's one of the objective issues that explains why there are violations of law. But if you take these violations, again an interesting picture. I didn't take statistics with me, but I can tell you approximately that about 2 years ago in Rospotrebnadzor report, it was written that there was a lot of complaints from customers on distance trading. If I remember correctly, in 2010 there were about 300 to 400 complaints. And I remember, of course, that distance trade in Russia has about 55 million buyers in Russia.
So what are 400 complaints versus 5 million users? Will you please formulate the main problem of remote trading in the legal field, and we'll discuss it after the break. Of course, the law on personal data, wonderful. So we're going to pass on to the theme after the break. Thank you very much. The main problem is delivery. That is mail of Russia. Not only mail of Russia, but in particular the mail as well. Thank you very much. Thank you very much. Ladies and gentlemen, we have a break now.
Вот теперь мы готовы продолжать. В связи с ограниченностью времени...
Now, since time is very limited, I suggest that we quickly exchange our experience and our information on protection of personal data and try and get answers to the questions we raised during the first session. Personal data and private life and personal life and different other types of information in the internet, that's a new subject of right and law. And it's a fact of life that this data is sold. And we keep talking about the threat that exists in the internet for the personal data. There is a lot of judicial processes in the jurisdictions outside of Russia. There's a lot of data for subscribers being used. This is not necessarily personal data, but we really have to distinguish between what we talk about, personal data that require protection, constitutional rights associated with the inviolability of personal and private private life and correspondence, and then at the same time there are other constitutional rights that are no less important, such as freedom of entrepreneurship, information, and so on. And thus, I do not really how to organize all of this, but I would just like to give the floor to a couple of speakers, because it's an open issue, an important issue for all jurisdictions. With the development of the internet, inevitably interference into private life occurs. At the plenary session, Prime Minister Medvedev was saying that they cannot upload judicial decisions because there is personal data in that. It does not mean that we should stop the free disposal of information we get from the public orders just because there is personal data about some subscribers or some other types of information that make it possible to identify them. From the point of view of the Russian legislation, I can see that there is a common problem, a lack of the way to distinguish between different types of data that we collect and that we process and use. And in these circumstances, of course, it's not the legal definition, but practice and judicial cases that can actually give us the answer to the question, what is to be protected and where the limits of this protection are, without violation of other recognized rights stipulated by the constitutions of different countries, and so that there is no danger to the creation of the innovation-based products. Victor Nevzorov, yeah, welcome. Anna, indeed, and colleagues, since we talk about the internet, it goes without saying that the technological realities of the internet, if we look at the communications, technological realities of the processes indicate that the subjects of relationship, to this or that extent, leave some information behind them, a trace. And from the legal point of view, we must resolve a number of practical issues, which these solutions might introduce a certain degree of approach to the solution of these issues. So, you know, that we talk about the protection of personal data. The law actually was amended many times, and this information nowadays is defined as information associated with the identifying person, a very vague definition. The definitions in the previous versions were clearer. If we remember the original law of 1995, there was just identification raised, but this particular law was revoked in the year 2006. So the composition of data to be preserved definitely has an impact on the interests of the sites, of the operators and the users. And under the present-day technological conditions, it is obvious that we actually expand the notion of personal data to cover all relations associated with private life. You know, these structures related to the subject can be treated in any way. And here in this context, in the West, there is a response, a clear-cut law enforcement practice. In some countries, there is even a closed list of data. In Russian realities, it is very difficult to work with this very unclear definition, with this vague definition, because actually the texts of the judicial decisions in media, for example, that is something that is perceived by different authorities, the violation of the privacy of personal data. And in reality, we can, due to the general wording, can pull to this instrument of protection anything we wish. And this is a serious problem indeed. The second one is as follows. Here, in this system of relationship, the state has created a rather devious system of organizational and technical requirements for information protection. It is a proper approach to a certain extent. There are certain types of data that are to be protected. There are certain spheres of activities to be protected. But there is the question of trust to business. Why should business operate within these very difficult conditions of information protection? After all, it's up to business. If they want to protect their interests and data, then it's up to them. If they prefer to keep everything in the desk of the secretary, it's up to them again. But introduction and intervention into this protection system is wrongful, I think. With the internet, again, we're talking about the agreement for processing. A year ago, all this became somewhat clearer. And then border transfer, this is something that we come across all the time. Insurance of banking activity, the internet shopping, all this is associated with the transfer of personal data. Data which inevitably has to be filled in the process during the transactions. So the law, by fact, due to the specific relations, is not observed by the actors. And one final remark. When we recollect what was said once about this, we keep saying that the strictness of our laws is compensated by the lack of their enforcement. If we transfer it to our sphere, again, there are strict requirements towards the protection of personal data, but the fine is just 10,000 rubles. So we had a discussion quite recently with colleagues pertaining to this particular situation. 10,000 rubles, if you enforce these rather complicated methods of information protection, is too low. It has to be lower, but let's not interfere into the process itself.
Let's then listen to Eric Altman concerning the viewpoint of American legislator concerning the protection of personal data and modern trends of development.
In the United States, we don't have a single globally applicable privacy law. We have various sectoral laws for different industries. We have special legislation protecting the interests of children, and we have various technology-rooted privacy laws. So we have special laws applicable to the rental activities for videotapes. There is daily effort among the regulators, federal, state, local, everyone, to create new privacy rights. Every day, the newspaper is filled with stories of politicians seeking new privacy rights. I don't know where this takes us, but there's no question that there's an incredible amount of energy being invested right now in expanding privacy law in the United States. What's interesting is that the incumbents, the companies that are already large and well-funded, are okay with regulating privacy. They're happy because that will raise the cost of new entrants into the marketplace. So the leading internet companies are generally okay with privacy regulation. They're working with the regulators to strike a deal that lets them do what they already do, but shuts the door on the next generation. And it bothers me that the regulators don't see that the regulators aren't recognizing that they, in a sense, are being gamed. In the United States, we have a class action system. That means that lawyers can represent a group of consumers as a class. The class action system solves some problems and creates many others. Privacy class action litigation is a major growth field in the United States. Lawyers have developed expertise in litigating privacy cases. They wait for internet companies to make mistakes. They read the research reports of security researchers and then immediately run to the court and file a lawsuit based on the findings of the security researchers, all on behalf of the consumers. So these lawyers often are acting in their own self-interest. They aren't actually concerned with whether the class gets relief. And so much of the privacy activity today is driven by the class action lawyers who are in the business of bringing privacy lawsuits. I think the biggest struggle we have in the United States is defining what a privacy harm looks like. When we see invasions of privacy that lead to financial losses, that's clear. When we see privacy invasions that lead to adverse consequences to consumers, that can be clear. But the privacy lawsuits we're seeing today have nothing to do with that. No consumer was harmed in the process, and we can't articulate how consumers have been harmed, and the laws therefore don't make a lot of sense because there's no victim whose issues need to be fixed. One last thing I'll mention, we do not have anything like a right to forget in the United States. There are a lot of efforts to create regulation that would allow people to scrub truthful, factual information from the internet. We don't have such a right in the United States, and it would in fact conflict with our constitutional protections in a number of respects. Yet, despite that, I see lawsuit after lawsuit, sometimes by crazy litigants, brought to try to create a right to forget under existing US law. Were we to have anything that actually resembled a right to forget, I shudder at the thought.
Thank you. I think that we are approximately in a parallel situation. We're debating similar aspects and similar questions that are discussed in the USA in this case, because the definitions are quite broad. The judicial practice is also not based on causing damage or causing harm. We also discussed the boundary between the misuse of the right, when lawyers are making business of it and they are waiting for a major corporation to make a mistake to start legal proceedings or to address Rospotrebnadzor for violation of the rights of an indefinite circle of the people, as it is quite fashionable now. And business that can be done using the information, non-personalized information which the major aggregators internet have. These might be social networks, mobile companies, major networks of remote trade and so on. They have a lot of information which they legally trade to the users. And in certain spheres, and we are closing our eyes on that, there is exchange between different persons, exchange of personal information, for instance, banking information, as we have already recently discussed with Viktor Nevzorov. This is a historical tradition, and it is not regulated especially, and nothing dangerous happens. So are we not trying by that focus and additional regulation in some way to create to ourselves some additional barriers for the development of innovations and entrepreneurship? Lately, I had such an impression that trying to protect the interests of an indefinite circle of people in respect of access to their information or the information about them, we thus create the new means of parasitizing on that public interest instead of rejecting it, so that the people themselves will be able to establish the rules or levels of access to the information which they would like to apply to them. Not the prohibitive order, but the order when you allow. If you want to prohibit access to your personal data, you can do it, but there are a lot of people, and the quicker the generation is renewed who is accustomed to living in the internet, the lesser are the number of people who take care about protecting their personal data. A lot of people appear who want to circulate their personal data so that they would be used. They just collect likes, and the number of hits at their sites and YouTube's increase. Probably we belong to the old school, and we shouldn't create any additional barriers or give additional definitions or create the institutions that would control the implementation by different companies of such rules. Instead, it is better to permit. If there are any comments, I am ready to discuss them. Please. No microphone, it is impossible to translate. It is impossible to translate without a microphone. Can you hear me? I have to introduce myself. So these initiatives have long been discussed with the Ministry of Communications, and recently they were approved, and we hope that this approve will make it possible to change the legislation. There are two principles existent in the European legislation: opt-out and opt-in. Opt-in requires use before processing personal data, and opt-out, it is circulated in the European, it applies to the main identification data in the European legislation. If there are no objections, you can process this data. So we hope that this will happen quite soon. Thank you. It is good that all of us in this room agree that we have to simplify regulation of personal data. If there are no objection against the last statements, I would like to pass on to the third part of our today's discussion that also seems quite interesting to me. And here, the main idea which we wanted to impart to that discussion is that innovations are impossible without the innovatively perceiving society or community. If we compare, as you said, as was said by Sergei Matveyev, that we have a historical ability to create innovations, but we don't have a historical ability, as in the USA, to maintain and support these innovations and their commercialization. And unfortunately, we have a negative experience of creating some crowdfundings, such as financial pyramids, and we don't have positive experience of creating crowdfunding as investments into the interesting innovative products, which are the main drivers of creating such an innovatively perceiving society and creating a comfortable environment for such innovations. Undoubtedly, state support is important. All of us understand that tax privileges and tax exemptions for the period when the activity begins and probably grants. Sergei Matveyev has mentioned that high schools will also participate in the process quite actively, and joint ventures can be set up to develop and commercialize the innovative products. The main task or the main interest is related to how we inbuilt into our legal culture such mechanism so that they wouldn't frighten away people and create additional possibilities for misuse, but they would really create business and make these activities interesting. Now I would like to give the floor to Igor Nevzorov from Ernst & Young Company, who has a certain vision concerning it. If you allow, I will make my presentation. Will you please show my presentation on the screen? Dear colleagues, I would like to cover the theme from the legal viewpoint, and my colleague will say a few words about crowdfunding from the economic viewpoint. From the legal viewpoint about support of the innovative businesses, I would like to dwell on one of the most important and acute problems for any global innovative business. Such problem is that of regional separation of legal regulation of the intellectual property. In any business, stability and definiteness is important. For any business, it is important to understand the risks related to certain jurisdictions when new products are brought to the market, and he will hope that the competitors would not copy the products. We can see that such definiteness is not related to global legislation now, and there is no stability. The slide shows an example of the well-known intellectual debate between Apple and Samsung concerning the design of iPhone. And in the slide you can see different forms of legal protection of intellectual property and different courts of law. What conclusions can be drawn? First, Apple doesn't always win and doesn't win everywhere. Though Apple has a legal service, Apple has significant investments not only into the product that is innovative but also into the legal practice of the company. Nevertheless, in the great number of courts of law, Apple would lose. Secondly, Apple wins as a rule in the jurisdictions related to common law jurisdictions and doesn't win in other jurisdictions. This is a separate question which shows why it happens. And third trend, in respect of some of the forms of the legal support, legal protection of the product, Apple would win, and in respect of other forms, it would lose. And there is a question, why does it happen so? One of the causes of such instability and unpredictability of protection of the product is the problem of regional separation. What is regional separation legal regulation? This is a situation when the same product brought to the market in different countries is protected differently, and the companies sometimes cannot see all the aspects of correct protection of their product within a certain country. For instance, iPhone in the Russian Federation is protected as an object of a copyright and a work of design. And in the UK, it is not protected in this way. In the UK, they have their own rules. And if iPhone is a market of more than 100 units, the copyright is not applied. And there are some specific rights, the rights for designing, which have nothing in common with a specimen, a prototype in Russia, because there are 5 forms, and one of the form is close to the Russian prototype. Another example, criteria of originality. In different countries, there are different criteria of originality as to what can be protected or not protected as an object of intellectual property. In some countries, such a telephone would be original. In other countries, it won't be original. There are examples from other spheres of intellectual property, the right of specific right, related right to the database. In the Russian Federation, in the European Union, they recognize not only the copyright but the related rights to database. Database users can be prohibited to extract separate elements. In the USA, there is no such right. In the USA, there is no right to a useful model as it is recognized in Russia and in certain countries of the European Union. Then to the countries of the common law, there is a separate right to news, and news are an independent object of intellectual property that can be prohibited for circulation and to which a monopoly can be assigned. That is particularly important for an innovative project in the internet. For instance, the internet portal would bring news to the third parties. If I have a monopoly, I can commercialize my news, and in Russia it is not possible. I have to proceed from the copyright, and there are some exclusions.
Thus, we can see that in different countries, in spite of the similarity of regulatory norms, and in spite of the existence of the conventions that are to harmonize legislation, there are different situations, and all the agreements, Geneva, Bern, and so on and so forth, they harmonize just the general layer of legislation, but not the specifics of the application of law and enforcement of law. And the second component is also in that. It's the organizational component in the work of different innovation-based companies. In our practice and experience, talking to our clients, we can see that the center of decision-making concerning the strategy of protection of design and intellectual property is usually focused in the headquarters of the company. And it is from there that the expansion of the company begins. Decisions there are made on how to protect the innovations and where to protect and where not to protect. And there is a negative aspect to that. As a rule, decisions are made by the lawyers of the jurisdiction where the headquarters is. So in case of Apple, this jurisdiction is the jurisdiction of common law. So they will most often win in the jurisdictions of common law and not in the jurisdictions of continental law. No matter how good the lawyers of the company are, very often they are unable to envisage complete global protection of their product in the countries of continental law. If I just ask questions without giving answers, this would not have been proper. So let's try to talk about the response of the business to that. Response can be given at the level of the company itself. If we take that the problem is the problem of centralization, obviously decentralization is a way out. A decentralization of intellectual property. A structure should be such for protection of intellectual property when the decision is made by lawyers from different law families, so to speak, from different jurisdictions, in order to avoid this notion that the center knows everything and is capable of protecting everyone and everything. Now, unless we talk about legislative amendments, and we can talk about these, but if we don't forget them for the moment, we can still think of how to protect our product at the level of the current situation of legislation in our own country and legislation of foreign countries, plus to the existing mechanisms, which are very often not effective enough. There must be used the methods of protection for IP that are quite universal. And among these unified and universal methods, there is not the copyright, because we know that these rights can be different, not the patent law and rights, because we know that, again, there is a great diversity in the countries, and the protection of patents in different countries vary considerably, depend on a lot of parameters. And obviously, for us, is the trademark very important, and the trademark is not just a brand, it's not just the image of an apple, but it's a new approach to the trademarks, which is being formed in the European practice and quite recently began to appear in Russia. It's not just an image, but it's an identifier. It makes it possible to identify the commodity in the market, comparing it to the products of the competitors. Even a gesture in UK can be patented. A person with his finger on the nose is actually registered as a trademark, and anyone who is trying to sell a product with that particular gesture is violating the law. So this is actually identifier. Visual trademarks do exist. Holographic trademarks exist. If we take products, then our idea is even to go further, because as an identifier we can use anything, not necessarily a symbol. It could be any identifier, anything that is original about our project, anything that makes it possible to base protection on it. If our product is the first first, let's say, the first dictionary that appeared in the internet, then why not go further? And why not say that the trademark will be the placement of our dictionary in the internet, and any other placement of dictionaries in the internet will violate our rights for the trademark? This idea for Russia is too revolutionary, because the Russian law and order in the sphere of intellectual property does not go that far in the way of abstraction. But in the future, this approach might allow us to protect our brand in a much better way. So trademarks in many countries are more unified than other IP objects. And if we apply the Paris Convention on Intellectual Property, then we need to remember the unfair competition. This institute just begins to develop. Foreign countries have a lot of practice in that. So if we invest into our innovation, if we invest money into the development of the project, and somebody else takes this product and uses it, then it's not fair. We say this is unfair. If it is unfair, then this is exactly what makes it possible for us to apply the construct of unfair competition. Although we have no other ways of legal protection of IP, the approach through the accusation of the counteragents in unfair competition can be an approach that applied not only in Russia but in other countries of the world. Well, of course, we're far away from harmonization and unification here, but this is a potentially usable approach. And then a third and more global and more strategic level, which is necessary for implementation in the future. It's an idea of global revision of all the concept of intellectual property in the world. At the moment, we have an enormous list of IP objects. There were authors in the 19th century, copyright began to be registered. Then, of course, there were records and e-databases and the software for computers, and we can talk about the protection of the rights of those who worked on that. Anyway, the idea of the global unification is the idea of not listing every single object, but the creation of a global object of intellectual property, the rights of which are to be recognized all over the world. Criteria here can be different from the ones we can see today. What is important from the point of view of the society and the market? Why is the protection of IP so important? First of all, we protect our investments. And secondly, we are able to say, this is our product, these are our technologies, and these are our innovations, and they make our product different from all other products. And so if we think of the unification, global unification of intellectual property in the form of a single object, then criteria for it can be based on the investments volume and on what makes it possible to distinguish our products from all other products. So this idea is at inception stage, and within the framework of the concept of the trademark. Yes, I have a brand, I have invested money into it, and it became popular in the market, and so this brand gives me a sole right to use it. And my brand makes it possible for me to ban the use of these brands and other similar brands by other parties. We can spread this idea at a different level. It can be expanded, and with similar mechanisms with investments, and these can work. A few years ago, Dmitry Medvedev, president then, spoke about the necessity to adopt a new convention regulating legislation in connection with the world entering the digital age. And as far as I know, this idea was not widely supported. But if we want the innovation business in the world to be protected all over in a uniform way, in order to be able to forecast the outcomes of lawsuits associated with IP, this is exactly the strategic approach on which all the innovation businesses should insist. Thank you very much, Igor. Now I would like to give the floor to Vitaly Kalatin, because he is practicing the support of innovation in his everyday work, a leading lawyer of Rosnano for intellectual property. When we discuss the development of legislation, support of innovation, and any other work in the field of law, we always want to understand whether our work is going to be successful in the long run or not, and what we need and what we lack in this sense. So we need to pay attention to three very important components, three elements, without which success is impossible. First of all, it's the legal basis. There must be a regulatory framework providing guarantees and rights for us. The second level is the level of the infrastructure in a conventional way. Instruments, sometimes legal instruments, are created at this level, and on the other hand, the opportunity for the implementation of the instruments is created at that. And the third level is often forgotten. That's public consensus level, because if we implement a legal construct, we understand this is a public instrument. It must work within the society. If the society doesn't accept it, it's not going to work. We remember laws with all the beautiful preambles sometimes never brought anything positive to life, and sometimes the result was exactly the opposite. So in the internet and outside the internet, when we take the legal regulatory framework, then we can see to 80% it's sufficient in Russia. It provides for the existence of the internet. It makes it possible to carry out commercial work and protect one's rights. But just at this level, we still have a lot of gaps. We still have a lot of gaps that do not make it possible for us to develop economic activity in this sphere properly. And we already discussed the personal data, and of course we have certain problems with regulation there. If we take e-commerce, again there are lots and lots of areas which are not properly regulated. The distance shopping is not regulated properly, advertising in the internet, protection of consumer rights. So all this requires separate regulatory norms, and cannot be this regulation cannot be carried out on the basis of the general norms that we have to full extent. But if now we can also say that the internet, we do have quite a system of laws. Now, as for infrastructure, of course there is legal infrastructure. Certain instruments are there for the enforcement of the rights. With the internet, though, it is very difficult, because if we take the fourth part of the Civil Code, we'll see that the internet is not present there at all. Something was envisaged, something was associated with the protection of intellectual property, but there were no special rules concerning the information medium. And this was done not by chance, or rather not by chance, because the third element is absent here. The consensus, the public consensus, is not there. It was not clear what the society was ready to accept and what the society was not willing to accept. So in this sense, we do not have enough legal instruments, but the project that we have and the draft document that we have, the drafted amendments of the Civil Code, will take us to the same level, the level of the sufficient number of instruments with the agreements that are typical of the information networks, and specific instruments. But infrastructure of this is a second part. Information bases are part of that. Dissemination information about oneself, and possibility of using the internet for one's own purpose. So when Rosnano comes to us, usually we meet a researcher who has invented something, found friends or partners, and they established a company that actually his idea is putting into technology. He wants to find money to promote it. The innovations are sometimes very interesting, probably protected to a certain extent, but very often they do not think about that, and It's part of our infrastructure. Indeed, the preparation of the necessary level of protection is something that needs to be done, of course. But over the years, the existence of Rosnano, sometimes a good project is not turning to be very successful for just one reason, because the person who develops that technology usually is a rather poor businessman. He is carried away with ideas, begins to invest money into something that is not that important for that particular product. You might have heard the plastic logic, that project of Rosnano, the tablets handed in by Chubais to Medvedev and Putin. Yes, it's an interesting idea. Plastic materials used for electronics, but these tablets, that was a dead-end invent, although probably they could have worked about some other applications for the same materials. That the technologists could not understand what was missing there, and the missing element is the professional business support. When at the level of the development of innovation, there must be a person who can develop the marketing plan, who can understand where this product can be sold. And I have been trying our applicants to make them prepare the documents describing how they plan to develop technology, where they're planning to sell it. They say, we have applied in the Russian Federation, we will get the patent in the Russian Federation, they say, and everything will be protected, forgetting that in the other countries...
So we have to think about it as well. We have to think for the future, but in order to do it, we have to attract the specialists who will help us, because the developer, as a rule, cannot do it. And finally, the third level, the level of consent. It seems doesn't matter what people think in the community. It is clear that you have to protect intellectual property. Even our present-day discussions. I visited a different section concerning parallel input and intervention of the anti-monopoly bodies. There is no consensus. People have different interests, and how it happened with internet when the fourth part was developed. People were not ready to protect the intellectual property in the internet, so we cannot say that it was impossible to speak about limitations for the intellectual property, because the right holders said that all the rights had to be protected, and another group said that the internet is a free zone, let it be free. So we needed several years from 2006, when our project appeared, and 2007 when it was approved, so that the society would understand that the right holders agreed to, so to say, reduce their interest, understanding they would never have adequate protection if they do not restrict their interests. And the society understood that they had to protect something, and only at this stage regulation can be started in that sphere. We haven't yet grown up to electronic libraries. We couldn't agree on the norms of the projects. There is no consensus, and this consensus appears at different levels, at the level of professionals, lawyers who have gathered here, and the level of laymen who express their attitude to intellectual property and the internet, and the third global level. When we discuss the international agreements, we do not rightly emphasize on the international agreements. That's why they do not proceed here. We shouldn't say that in the internet we shouldn't protect the international property, but the international property should first be a certain consent, a global consent, as to how we should regulate that sphere. If these principles are inherent as to what we are doing in that sphere, then we'll have to develop the basic principles and terminology in that sphere, as was mentioned by Victor. Otherwise, we will never be able to agree how we would regulate the internet websites, because in some countries that will be related to information law, in the other country intellectual property, and and how the intellectual property should be restricted, to what extent. It is impossible now to get the international agreement, so there is no third component at the international level, and so far we won't be able to come to the final success point. We'll never be able to regulate and to say that in internet we have protection of intellectual property and innovations, because at this level we haven't yet reached the consensus. And this vision of 3 stages, of 3 levels, makes it possible to understand at what stage we'll be finally able to come to the situation when this system is full-fledged, or probably we need several decades for that. So far we see that this cannot be solved today, but this question requires a longer period. And for Russia probably this is a more complicated environment, because we don't have sufficient consensus and infrastructure, and the law is just developing, and beyond internet we also don't have successful regulation. That's fear. We're just making errors at Rosnano, at Skolkovo and elsewhere, realizing these projects, and probably will get some result. Thank you. Thank you very much for a very interesting presentation. It should be noted that recognition of the state and state authorities as such organizations as Rosnano and Skolkovo, that without businessmen it is impossible to do business, even if the idea is quite bright. That is a message that is quite pleasant for the business, and probably it should be deeply rooted in the minds of the officials and innovators. And I think we'll have to work on creation of such joint possibilities from the viewpoint of innovators and business for the joint development and promotion. Now I would like to give the floor to Anna Fokina, who represents the Ministry of Communications, the Department of Development of IT sector. Thank you, Anya. And I would like to thank you thank you for mentioning the theme of interaction between the society, business, and the state. We cannot do without it when developing our sector. My colleagues today compared different legal national systems. I'm developing the venture sphere in IT sector at our ministry, and I often compare Anglo-Saxon, Roman, German law systems as how certain legal mechanisms work in both systems. And I'm often asked why Russia is not the USA. I don't like that question, so there were a lot of answers, but after today's presentation of Mr. Goldsman, I know if you lack sunscreen, I lack mittens and a scarf in St. Petersburg to analyze and to see the sites and its beautiful architecture, because I'm frozen here, and some legal instruments work adequately, and they say we cannot copy-paste them and transfer them to Russia for different reasons. And for these instruments to be operational, we have, on the one hand, the state should help but not interfere when it is not necessary, and we also need the initiatives of business and community. And today I would like to briefly dwell on how we can finance the development of innovations, and why the development of innovations differs from the financing of any other business, why it should be more innovative, so to say. I'm holding an excerpt from the report of the Association of Companies Upkeep of Computer Information Technologies, which they prepared together with McKinsey. And according to that report, the place of Russia in the rating of the countries which are currently actively developing IT sector is 120 place from 142 countries. We raised 6 levels since the past year. There are some criteria such as protection of intellectual property, as was mentioned by Vitaly, time that is necessary for launching business, and other criteria Why are these criteria important and how can you affect them? I'm going to talk about it in detail. If we speak how the innovative company develops, we might distinguish certain tackles. Seed financing, sorry for using the English terms, but as was mentioned by Anne, there are no Russian terms that would adequately reflect the essence of such phenomena. I will briefly clarify what is seed financing. Seed financing stage is a stage of development of innovative companies when they have an idea and nothing else except an idea, or they want to implement that idea. Just what are the financing funds that are available to the innovative company? The so-called triple F, family, friends, fools. As was mentioned by Mitali, a claimant can come to Rasnano with money from his friends, partners or fools who just were mistaken and gave money to the project that might not be liquid. What other funds means are available to the information company at the early stage of development? Incubators and accelerators, they are quite common in the USA now, and in Russia incubators and accelerators also appear in great numbers, but they work based on the system. When they want to have a return on their investments right now, the incubator commonly gives a virtual place and along with it a real place on some site where the innovative companies get together like the stock exchange, similar to brokers. They are next to each other and implement their projects. However, in the USA, quite often incubators and accelerators operate on a free basis. In Russia, both often require a share from the innovative companies, a share in the share capital for that support. Thus, that interferes with the actions of the innovative companies. They're afraid to give a share to not known people and don't understand. They don't understand why they should give that share without real financing. There is another term, bootstrapping. This is, in fact, a requirement which the investors impose on the young innovative companies, asking them to have the maximum restriction on their capital, at least at the stage of seed financing, to prove that even having a very limited funding, it is possible to bring their idea to a certain level, and then when it is formulated, you can ask for additional investments. And another source of financing that was mentioned by Anna today, the so to say crowdfunding, which is developed in the USA. And last year, the so-called DROPS Act was adopted, our Business Startup Act, according to which financing of the companies can be granted by private persons or association of private persons, and tax privileges will be granted. That is a general exception from the regulations which Security Research Commission, that is an American analog of Ethisphere, grants to innovative SMEs for their development. Of course, it is good if we had similar instruments here in Russia, but so far they are not available, and they won't grow instantaneously, and probably some time has to pass before such complicated, innovative methods of financing will be incorporated in Russia. That is pre-seed and seed financing stage, financing of the idea. Then idea becomes a term that has become Russian, a startup term, though in fact this is also a British word, and there are two most popular sources of financing: business angels and venture capital funds. Business angels and venture capital funds. And venture funds really can finance at the stage of startup, but it is presumed they offer to the companies to use the assistance of business angels, smaller investors, which will give additional capital. Probably it will not be significant. It will be sufficient to pass to the next stage when the venture funds would feel more comfortable to enter. And I have analyzed the last updating at Ernst & Young. There is an active group dealing with research at Ernst & Young in the sphere of financing of innovative companies. According to reports of Ernst & Young, lately in the last years, and particularly in the last year, in G20 countries, a major place is taken by financing at the stage of startup and financing or from business angels, not venture capital. In Russia, private individuals will finance their companies most likely if they know with whom they have to do, or on the basis of friendship or good acquaintance. The next stage, the so-called emerging growth stage, when the company reaches a certain level of development and essentially it needs additional capital for batch or serial production, extensive production. Here, several mechanisms of financing are available. The financing that has been mentioned from the venture fund or the state might offer different mechanisms of financing that consist not only with transferring the money or grants as it is done by Skolkovo or other institutions of development.
But here, there can be other schemes like credit guarantee scheme, or the bank guarantees well spread in the United States. A colleague from the States, Mr. Goldman, might speak about this. This is a system where the banks finance innovation companies, and if it is impossible to get the loan back, or if there are delays with the paying back of the loan, the state acts as a guarantor in its relations with the banks, and can cover the credit or the loan paid out to the innovation company. There are other interesting methods of assistance to the innovative companies, and this demonstrates that society, the public sector and business cooperate. Retain agreement is a very popular notion, well known in the States, but not that popular here at all, although there are different opportunities for it to take root. Retain agreement actually means that lawyers can provide free help to the innovative companies, signing an agreement with them that these lawyers, once helping the company, will be paid when and if these innovative companies reach a certain financial level. For example, if the annual turnover of the company reaches $100,000. I know that my time is over. No, I really do not want to stop your story because this is most interesting. This is a systemic approach, but it is, yeah. Now the discussion. Yes, I'm very, very much willing to discuss. Let's not mix up the startups. A lot of terms were used by you. Now we have very well-known terminology, seed funding. And there is a system of support for the seed funding. And there are special programs. If we take the student projects, for example, competitions, Umnik and others, 300 to 500 rubles can be allocated for the implementation of different things. Classical mechanism of startups, there is the Fund of Entrepreneurial Support in Science and Technology, which supports SMEs on the basis of an open competition. The basis of priorities, allocating a couple of million for the first year, then 2 million for the next year, and so on and so forth, with increasingly. Venture companies, that's a separate story. Then there is Skolkovo, of course. There are technological platforms. So why do I want to talk to you? Really, practically all the funding instruments are there, except for the loan interest rates. Yes, of course, we have problems with that, but there is also a joint Russian-American group on the analysis of legislation in the field of intellectual property and commercialization of ideas. And the last report of this group dedicated to the comparison of the legislation shows that what concerns SMEs is actually being implemented in our country. So information perceiving society, just one example, if I may, a positive example, the best in Russia. We have the Belgorod Technological University. The rector understands everything. 3 years ago, he read a law on the small innovation-based companies. Well, of course, he began to think of who is going to establish them. Obviously, if there is a law, the government wants them. So they introduced the course of intellectual entrepreneurship, but actually, about 40% of those who graduate from there graduate with business plans ready, and out of these 40, 7 to 8 are quite acceptable, and 7 to 8 percentage, that's quite enough for them to win in our competition of startups. In 2011, they were able to win about 30 million of public money support, and they have 66 small businesses, 400 new jobs, and their turnover in 2012 was 170 million. With that small amount of money allocated for them, the wages were increased by 2 to 4 times. And what else is there? What else is there that they need? Allow me to say, we are talking about information and the internet, about the need to protect the information. When we were getting ready to this discussion, we looked in the internet and for the information of what Russia is doing to support innovation, and we found some bits and pieces. Unfortunately, there is no concept, no program, no popular explanation of what you are doing. No, I'm listening to you and I'm saying that this is all wonderful, these are outstanding approaches, but nobody knows about them. That is the problem. About the fines of Roskomnadzor, everyone knows, but about the support for innovation, nobody knows. Because in Russia, we want to listen to the negative things rather than to the positive ones. That is the problem with us. Within the framework of the strategy, we were saying that we really need to involve the associations and the chambers of industry and commerce. We have so many associations, and no one in these associations is associated as involved with promotion. So that means it is necessary to remember that, and the public is quite passive, and there are disputes within the internet. But show me, mention to me at least one NGO that is involved in mediation here. We have a federal law on mediation. We have people who have been robbed through the internet, and everything like that is known. Yes, we know how it is happening with the hits of some of our musicians, but even before going to court, lots and lots of problems can be settled through mediation. So here we go back to the issue of innovation and information perceptive society. So one example, instead of building stations in Tudra, I think we should spread information about the information activity of the Ministry of Education and Science. It doesn't cost that much and the use is much greater. You are talking about being forced to do something. You either want to do it or you don't want to do it. We are willing, but we do not know that there are these opportunities open for us. Well, thank you very much for turning my presentation into a discussion. And really, I do not deny at all that there are initiatives. Moreover, in our department, I'm popularizing, promoting these initiatives, and that's what I'm doing here as well. But I started by saying that there is no interaction between business, society, and state. Let's take the Bortnik Foundation. Support of SMEs in science and technology. Yes, they have the UMNIK program, but it's for school children. But the audience here, I think, is beyond that age. Another program is called START. It's for students. For the young entrepreneurs, yes, they can get 1 to 2 million. If they are successful, they can move towards the LEADER program. This program is insufficient to cover all those who want to take part in it. And there are not that many programs like that in the United States. Now, I don't want to say that in Russia everything is so bad. No, Russia is different, and of course we have a lot to learn from the States, but knowing that we cannot just borrow something and without any adoption. There must challenge. It's an accelerator from Massachusetts challenge. Yes, it's a bit difficult for me to translate some of the terms into Russian. That's why I'm using so many English terms. It's a classical accelerator, one of the biggest in the world. And last year, I worked with it and could see 3 teams reaching the finals. And one of these teams was from Novosibirsk University, where researchers at the chair of mathematics invented a formula that later passively was just sitting somewhere on a shelf on a CD, until students realized that it could be in the basis of an algorithm capable to read and to understand better how to lay a cable through a building. So they brought it to the competition, and among 1,300 companies were able to win and reach the finals. So just an indicator of how interaction is possible in the state, where accelerators are created and where the society, business and the state are involved, and where the doors are open not only for American students but for the Russian students as well. That's the way to get funding. So we would like to see that here, not only through the interference of the government and through government-instituted entities. Understand that no matter how many institutes we have, we are not going to achieve much unless there is a change of attitude and mentality. So that means there must be a wish to patent, there must be a wish to defend, to protect patents, to find funding and be responsible for the money received. Without that interaction between the society, business and the state, success is hardly possible. The society doesn't seem to show any interest in innovation. There's not enough information. There is a lot of information, but we are unable to see the mutual wish. Yes, so there's a communication problem, I suppose. We're in this beautiful city of St. Petersburg. Let's involve Megaphone into this discussion. I mean a very different type of work. A few weeks ago I was here and we had a meeting on IT cluster development here. We invited universities to that meeting, invited all the well-known schools of the city, the Bonch-Burevich School, the Institute of Optics, and invited military companies, and there were many participants, discussed the new models that introduce changes into the law on education. We have created a very easily understandable corridor which enables business to avoid heavy taxation. From September, companies created by the universities will enjoy very low taxes, and they really enjoy enormous benefits. And there is no limitation of the share in the statutory capital or the business involved in R&D. If there is a company working in the R&D sector, they can establish a small business.
Essentially creating an outsourcing satellite, having the inflow of young specialists and saving money. Thank you very much. At least one person from the audience or two persons would ask questions, and then we'll finish our meeting. I'm not asking any question. I would like to make a comment concerning the knowledge to the community. Probably this is a problem in reality. Currently, in principle, the state authorities are quite adequate while they receive the information from the business. Therefore, it is rather comfortable to work with them in most cases. And then the next major group are the development institutes and other institutions supporting business, and then the land proper. For instance, as Sergei said, what am I going to do with it, where I should go? There are different programs. I'm not speaking about Skolkovo. There are different institutions in the regions that collect the project. But we don't know how to solve this problem because our people are not quite active. Speaking about innovators and the right holders, all the instruments are available. We have good laws and we have good law enforcement. We can just take a step, one step, but they're not doing it. They have difficulties in changing their mentality. If you don't understand the causes, you should conduct some sociological research and you will draw the conclusions concerning these causes. Should I tell you about it? In fact, in the system of high schools and scientific institutions, about 55% think that it is better to engage in private business, to grow something proceeding from their ideas, and everyone is for private entrepreneurship. And the same percentage, about 50% of the respondents, so the difference between 50 and 60 is given by 10% who are working. They think that laws in the state are such that nothing will come out of it. They will collapse and they will lose money. They do not trust the banking institute and loaning, that they don't want to take loans, and they don't believe in the ideas. So that is a problem related to PR and related to psychology and perception. That is PR. If we, for a couple of words, tell people how good it is and give real examples so that no one would be imprisoned for that, the people will change their opinion. Such stories have started. We'll give the floor to your American colleagues, but everything was good with PR in the USA, I think.
I wanted to add two things that I don't know if they are different from Russia. First, in California, non-compete agreements are void, which means that employees cannot be restricted from going to competitors, no matter what the contract says. That has created labor mobility in the state. That isn't true in other states in the country. But the other thing that's different about the Silicon Valley, and I know many people have wanted to replicate the Silicon Valley economy, the one thing that I think stands out above all others is that the prestige jobs for college graduates is to go to startups. They don't want to go to the institutional players who are the well-funded incumbents. They want to go and try and hit the home runs by going to startup enterprises. And that's a cultural norm that perpetuates startup creation because you can get a ready supply of talented expertise into your companies. You can hire them from your competitors, and you can hire from the college graduates who are willing to take those risks to work with startups.
Thank you very much. I think this is the end of our roundtable discussion. And we have to think about many things. Probably we're doing everything correctly, but we do not succeed. Thank you.